All right, well, it is past 1:30, so we'll get started here. Welcome, everybody. This is Eric Hauge, Executive Director of Homeline, and we're joined by Homeline's Managing Attorney, Mike Bra, who will be doing the presentation today. Again, today is Wednesday, May 27th, 1:30 p.m., and this is our sixth, I think, webinar that we've held on rental housing legal issues related to the pandemic. Reminder, Homeline is a statewide nonprofit organization. Our main program is a free legal hotline that renters can contact over phone or email in 4 languages: English, Spanish, Somali, and Hmong. We have been holding these webinars since mid-April on a weekly basis, and we will intend to continue to do that for the foreseeable future, as we've gotten quite a bit of feedback that's been helpful. So every Wednesday at 1:30 is our tenant and advocate and social service provider focused audience webinar, and Thursday at 1:30 is our landlord and property manager events. And all of the links are on our website each week. The one additional thing I'll add today is that we will, next week, one of our attorneys, Spanish-speaking attorneys, is sort of co-hosting an event that will be broadcast live on Facebook with clues. It will be an entirely Spanish language webinar over Facebook Live, and I'll put a link in the chat in just a moment. With that, I'm going to pass it over to Homeline's Managing Attorney, Mike Bra, to get us started.
Thanks, Eric. Hello, everyone. Thank you again for joining us. And for those of you who've come in for the first time, we appreciate you tuning in today to learn about landlord-tenant law in the COVID-19 era here in Minnesota. As Eric mentioned, today's May 27th, which is a Wednesday. That's important because of a couple of things. First of all, we try to say the date frequently throughout these. We actually make these available so people can watch them later on, but we are very familiar with the concept that what we say today might not be the correct answer to a question a week from now, or 2 weeks from now, or a month from now. So the advice we're giving today is based solely on the information we have today, May 27th, 2020. We're closing in on the end of a month that matters quite a bit in the landlord-tenant arena for a couple of reasons. First, the end of May is a very common day for tenants to move out of a rental unit. And one of the questions we have been asked since this all began, the COVID-19 epidemic, I say mid-March, when it's really started to impact our line of work, is whether or not a tenant is allowed to move in or move out of a rental unit. It's a little easier to answer now than it was at the beginning of the COVID-19 pandemic. Then it wasn't entirely clear under the governor's shelter-in-place order whether a tenant could move in or move out of a rental unit. But that has since been modified, and that question has been answered with some amendments to the shelter-in-place orders that have happened subsequently. So yes, a tenant is allowed to move in, a tenant is allowed to move out of a rental unit, and that will be happening tens of thousands of times in the next week, probably, because that's when tenants move in and move out, is during the warm weather months. So we have a 5 or 6 month window that is where almost every tenant move in, move out happens in Minnesota. Now, of course, some people do move out at the end of December, the end of January. It's just that nobody prefers that. So that's not generally when people move in or move out. But it is allowed on both the landlord side and the tenant side to let somebody move in and let somebody move out. We have an hour today. And I'm going to talk about a couple other things before we get to questions. And I know we have one pre-submitted question. But other than that, we are wide open for the questions that you want to ask about. And so we have no questions submitted on the Q&A or chat. That's primarily what we're hoping to do with most of today, is to answer questions that people have about the rules as they are, wondering what they mean or how they apply to the situation that you might be in. So hopefully we get some questions. I'm an attorney, which means at some point you get programmed to be able to talk endlessly. So I can certainly cover an hour, just sort of hypothesizing and going into different topics about landlord-tenant law, but I'd prefer to know what you want to know, and then I can answer those questions. And if I can't, then perhaps Eric can. Some of them are policy-based, and that's his expertise more than mine, where I work solely on the law. The other reason, though, that the end of the month is a big deal in landlord-tenant world is that's when leases generally say rent is due. So not the end of the month, but the first. So on June 1st, which will be this weekend, the rent will be due for tenants. Now, when COVID-19 began, there was a giant fear that I think was very justified that tenants wouldn't be able to pay their rent as their job losses would start mounting. And we've all heard about the unemployment figures. And so many of our clients, of course, are without jobs at this time. The unemployment has been coming in. The federal stimulus money came in. So the April non-payment of rent numbers, the figures, the statistics from landlord groups, which is really the only group that can tell us the answer to this question, wasn't as high as had been feared originally, nor were those numbers as high in May as had been feared originally. The theory being that people have been getting the unemployment and the federal stimulus payments, so tenants just had more money in their pockets than they had suspected that they would. But as this drags on, as the pandemic drags on, and people are still without work, giant numbers of people are still without work. The question happens every month on the first of each month: will the rent be paid by the tenant? Can the tenant actually pay the rent? Do they have the financial ability to pay the rent? And so undoubtedly, we'll be getting calls between now and June 5th. That's sort of that window where tenants really start to worry about payment of rent more than any other time frame, is right before and right after the beginning of a month, asking if they have to pay their rent or not. What if they don't have the money? At present, the governor's moratorium on evictions remains in effect. It is in effect through June 12th. This is very confusing to follow along, to try to figure out what the eviction is tied to if you're not really sort of digging into what all the orders mean. But the eviction moratorium, which also bans terminations of tenancies, so where a landlord is telling a tenant to vacate without going to court process, is through June 12th. That is the current end date that we know of. Now, we have done this, as Eric mentioned, 6 times, I think, where we talked to tenants and tenant advocates on the Wednesday sessions. And we have mentioned other deadlines where the moratorium would end because the governor has renewed or extended the peacetime emergency, which is what the eviction moratorium is hinged upon, not the shelter-in-place orders. So those dials that we've been seeing in the newspapers and online, where the governor has mentioned that we can open up a new facet of life again. I think, for instance, that salons are going to be openable on June 1. So they're starting to move the dial a little bit more on the types of businesses that are going to be open. Those don't have anything to do with the eviction moratorium. Those dials don't. That is tied strictly to the peacetime emergency, which authorizes the governor to do most of the things the governor has done since the COVID-19 epidemic began. So that is the critical question about when a landlord can go file an eviction for non-payment of rent or for any other reason other than if the tenant has drugs or illegal weapons or prostitution or stolen property, or they endanger the safety of other residents. That's the only exceptions where a landlord can file an eviction today in Minnesota. And again, by filing an eviction, I mean go file the court case where the court effectively, through ultimately the sheriff's authority, granted an order from the court, can remove a tenant physically from a place. That really can't be done for most of the reasons why landlords traditionally file evictions in Minnesota. Almost every eviction in Minnesota is for non-payment of rent, well over 90%. And so that's the general reason why landlords file evictions. And right now they can't file an eviction through June 12th because of the governor's moratorium on evictions. Now, that's not the only question that we have to answer when it comes to when can the landlord file an eviction, because we have a federal rule, which is very uncommon in our line of work. Landlord-tenant law is almost always state-specific and sometimes even county or city-specific. And because of the pandemic, the federal government, so Congress, the House and the Senate, and the President passed what's referred to as the CARES Act, which is a long piece of legislation, but one of the things it talks about is housing and in particular rentals. And it bans, once again, evictions through a certain date. In this situation, it's July 25th that those evictions are banned through. On July 26th, if a tenant still owes rent, by the way, that's just for non-payment of rent cases. So unlike in Minnesota, where you can't file an eviction for a tenant having a dog when they're not supposed to right now, the federal moratorium on evictions is only for non-payment of rent cases. Anyhow, tenant doesn't pay through July 25th. On July 26th, the landlord still can't file the eviction. They have to give a 30-day warning to the tenant saying, hey, pay up or else I can file the eviction. So effectively, if the CARES Act is in play for a landlord, then they can't file an eviction until late August. A harder question is whether the CARES Act applies to a specific property or not. Now, there are many properties that obviously apply where there's a federally based subsidy attached to the building or to the complex. But it could be a Section 8 voucher. It even could be something like a 1 to 4 unit rental, or maybe the landlord lives next door in a duplex where the mortgage is federally backed by Fannie Mae or Freddie Mac. Those would also fall into the CARES Act. Our best guess, and this is still a guess because some of this is frankly unknowable for somebody just looking from the outside, is 20 to 50% of the rentals in Minnesota are covered by the CARES Act. We have been seeing evidence, and it sounds like from the sort of the lead housing court in Minnesota, Hennepin County, that they're going to be requiring landlords to submit evidence that they have complied with the CARES Act. We've also seen that done in other states, not complies with, but they're not bound by the CARES Act prohibition when they file an eviction. Now, evictions aren't really fileable, once again, in Minnesota right now. So we won't see the effect of how that's going to play out until the courts are open up again, whenever that happens, assuming that the state moratorium isn't lifted before the CARES Act moratorium is lifted. At some point, that probably seemed like a distant possibility, but it is going to be June in a couple of days. So it would only take, I guess, realistically 3 more extensions before the CARES Act wouldn't be a question anymore. Unfortunately, if that was the goal for somebody to have, to line things up with the CARES Act, the dates where the governor can extend the peacetime emergency don't really line up. I suppose it's possible the governor could end the peacetime emergency on the same day the CARES Act moratorium ends. I think that's possible, but the peacetime emergency is not just about evictions. It's got a lot of other components to it, so I think that's possible, but unlikely that the governor would tie the end of the peacetime emergency to that. But we can't be sure of that. That being said, I know we had one question in advance, and we have a couple that have come in since. So Eric, if you want to give us that pre-sent question now, that would be great.
Yeah, the question is, can a landlord put off a repair temporarily due to COVID-19, perhaps out of fear of contracting the virus? What are the tenant's rights in a situation like that?
Yeah, so when we're not in the COVID-19 era, the number one reason people call our tenant hotline, where we take 15,000 calls a year, we advise renters for free, both on our tenant hotline and through our email and attorney service. The number one reason people generally call us is the landlord isn't making repairs. Every year in every city, that's the top reason people are calling us. But not now. COVID-19's changed that, why people call. They have different issues that have come up since COVID-19. But the repair question still remains. We still get quite a few calls where tenants say, hey, I want to have a repair made. I want the landlord to come in and make this repair. And some landlords are saying, okay, and we'll take all appropriate safety measures that we can under the current known guidance from the CDC and whoever else might be giving official guidance. But yeah, we'll come in and make the repair that you need made. Other landlords have been saying, no, wait, if it's not an emergency, we're not going to come in to make the repairs that you're asking for. It's just not going to be something we're going to do. So can a tenant force a landlord to make repairs? Well, first of all, it's not against the law for the landlord to come in. I think even the earliest shelter-in-place order granted landlords the ability to enter a place for business purposes and to conduct business. There's an issue about whether the tenant has a right to privacy and they can stop the landlord from coming in, but if the tenant's actually inviting the landlord in to make a repair, it's a whole different sort of footing that we're asking that question from. So a landlord, I think, unquestionably has the right to go in to make repairs. If the landlord is concerned, hey, am I breaking the law, any of these orders by going in to make a repair that isn't an emergency because the tenant has asked for it? No, the landlord is not breaking any law to go in and make a repair at present. Again, especially if the tenant is inviting them in to make the necessary repair. But what if the landlord refuses to make the repair? What can a tenant do? Well, the normal remedy for a tenant is to file something called a rent escrow. There are some other choices. They could call a city inspector, and they can still call a city inspector. And some cities are only coming out for emergency issues. Some cities are doing inspections via photos, so the tenant will send in pictures by email or some other way to demonstrate the issues that they're dealing with. So that's always an option, as a tenant could contact a city inspector, and in some places that makes sense. Not every city has inspectors in Minnesota. Most of the metro cities do, and the larger cities in greater Minnesota as well, but not every city in Minnesota has an inspections department. But that is an option, to call an inspector about a repair issue. But the other option is the one that most tenants avail themselves of, which is to either threaten to or ultimately file what's called a rent escrow. A rent escrow is a court case that a tenant files against a landlord. It costs about $70 for a tenant to file a rent escrow, unless their income is really low, and then they can get that fee waived, and then they don't have to pay anything. And no attorney is necessary to file a rent escrow. But how it works logistically is the tenant says in writing, landlord, here's the problem, you have a couple weeks to fix it. 2 weeks later, if the problem isn't fixed, then the tenant has the right to file the rent escrow. In fact, the repair request form letter is by far the most downloaded letter that we have on our website. We have one that we drafted years ago, and it's been used hundreds, if not thousands of times to start rent escrow cases since we opened, frankly. And it cites the key law that covers repairs that need to be done in a place, the state law that sort of dictates all the rest of what happens with repair issues in Minnesota. Anyhow, the tenant gives this letter. 2 weeks later, if the repairs aren't made, 2 weeks after the landlord has a letter, then the tenant has the right to file the rent escrow court case. If they file it under the law, they're supposed to be guaranteed a court date within 2 weeks of filing the case. COVID-19 has changed many things in the law, and one of the things that has changed is the court is allowed to go past statutorily required deadlines. So if a tenant is thinking, I'm guaranteed court in 2 weeks, I can't actually make that promise once the courts are open for rent escrows. Right now, they aren't taking rent escrow filings. They're hoping to start doing some rent escrows that have been filed prior to the closing of the courts. So they're active cases, they were already filed, and they're going to try to schedule them at a time. And I know that they're getting some of these scheduled now in the metro area housing courts. Hennepin and Ramsey County have specific courts designed just for housing. It's mostly evictions, but they do rent escrows as well. But anyhow, they're trying to get those set up. But if a tenant were to file a rent escrow right now, first of all, I don't think they can actually file the rent escrow, but if they were to file it, it's not going to get scheduled anytime soon. And I can't say exactly when that would occur. Does that leave the tenant with zero options? Well, sort of a theoretical option that's been asked about in our office, and we've discussed it. We have 7 attorneys that work in our office, and we've kicked this around, and I'm sure that folks at Legal Aid have talked about this as well, is that a tenant is allowed, even under pre-COVID-19 rules, a tenant is allowed to withhold their rent, to try to force a landlord to make repairs, to simply stop paying. Now, normally that's not advice we'd ever give a tenant, because the risk of withholding rent is that the landlord will go file an eviction. An eviction on a tenant's rental history means that in the metro, 75, 80, 90% of landlords might turn them down if there's a recent eviction filed against them. So it's a massive risk to withhold the rent to try to force a landlord to make repairs. It's legal. It's not a criminal act. And a tenant is allowed to do this based on a court case that goes back to the 70s, a Supreme Court case in Minnesota. So they're allowed to do it, but the risk is so high of having an eviction on their record that might stay there that it isn't worth it to withhold the rent versus a rent escrow. But right now, since rent escrows aren't really available to tenants, does it make sense for a tenant to withhold their rent? And the longer this drags on where a tenant can't file a rent escrow, the better argument I think a tenant has for withholding their rent. I'm still as an attorney that's been doing this since 1996, it's sort of hardwired into our programming to say that withholding the rent is a bad risk. But it's a more justifiable risk now than at any time in my career, certainly, where the landlord can't file an eviction for non-payment of rent. So the landlord's remedy is really limited there because the tenant's remedy of the rent escrow is limited as well. The withholding of rent might be the one way that a tenant can force a landlord to make repairs. Now, again, the big risk with that is at some point the governor is going to end the peacetime emergency or stop evictions from being prohibited. We don't know when that'll happen. And judging by some of the past declarations the governor has made in the last couple of months, sometimes there's no warning at all. You know, starting right now, this is open, and nobody was really aware that that was going to happen. So that's a possibility, is that the governor, I guess, could say tonight that, hey, evictions are fileable again right now. I just decided it. And then tomorrow morning, landlords could go file the eviction. So there is a risk with withholding the rent. And it's a hard one for, again, somebody that's done this for a long time to say, yeah, go ahead and withhold your rent, because I understand what the downsides are, and they're so hard to get past that it is something I'm still nervous about saying. But it's like I said, it's a better option now than it's ever been in my career. And it seems to get like a more reasonable option as this drags on. Longer answer than they were probably looking for. Sorry about that.
Yeah, so then we do have a couple questions that have come in now, and feel free to submit at any point over the Q&A or chat. First question: if a tenant has a balance on their account when they move at the end of this month, when they move out at the end of this month, but they are not able to pay it, what happens with that tenant?
Yeah, so this is going to be something we're going to see a lot of in the next month, 2 months, 3 months. There's no way we won't see a lot of this. So, okay, I'm trying to think of this sort of from the tenant's perspective here. A tenant that doesn't have the money, what do? If they want to move out right now without having paid rent, let's say they didn't pay May's rent or even April's rent, so they're behind a couple of months. And we'll use $1,000 because it's easy math to figure out what makes sense for the tenant and for the landlord here. So the tenant hasn't paid for April or May. They're $2,000 behind, but their plan all along was to move out at the end of May. They're going to move somewhere else, maybe with family, friends, moving to another state because of a job they got lined up, whatever. And they leave now. What happens to them? What can the landlord do? Well, the first question that I would answer for that tenant, if they were talking to me on the phone, and they might not even ask this question, but I'd make sure to point it out, is that if they leave, the landlord can't file the eviction against them. Why that matters, like we've talked about already today, is we want to keep evictions off tenants' records. It's so damaging to a tenant's ability to try to get a rental in Minnesota to have an eviction filed against them that in some cases it's better for a tenant to walk out the door than it is for a tenant to stick around, wait for the eviction, and get more time to stay in the place they're in. Evictions take 20 to 30 days on average, is how long a normal pre-COVID-19 eviction takes for a landlord from the day they file the case to the day the tenant has to go. 99% of evictions are done within that time frame. Many are done within 2 weeks. But maybe it's not worth it for that tenant that hasn't paid rent for a couple of months to get that extra month. If they were going to go anyway, leaving before the eviction moratorium is lifted has some merit for that tenant because they're going to keep the eviction off their record. A landlord can't file an eviction if the tenant is no longer in possession of the rental. So the tenant needs to actually do something to make sure the landlord understands that, right? Return in the keys is sort of a baseline minimum, or a letter saying, you know what, I'm never coming back, the place is yours, or an email or a text, something giving up possession. But if a tenant has actively given up possession, moved their things out, or said, you know what, I've left and my stuff is I'm never coming back for it, then the landlord can't file the eviction or shouldn't file the eviction. Why waste the $300 to file the eviction? And they'd have to sign under oath that the tenant is still in possession of the rental property, which they wouldn't be. They wouldn't be in possession anymore. So the landlord would be wrong to file it. They'd be wasting money. A landlord, all they really win in an eviction, if they win the case, is possession of the rental. They don't win money. They have to go to a different court. So my first concern about somebody that's talking about leaving at the end of the month is, okay, how do we make sure that the eviction doesn't go on your record? And right now, that's pretty simple because the landlord can't file an eviction. But again, that moratorium will be lifted eventually. We don't know when, but when it is lifted, then the landlord will have the power to file the eviction again at that point. The other concern that the tenant that's leaving has, though, is that there's a bill, there's a debt due to the landlord. Assuming there was a security deposit for a second, and we'll just kind of use average, again, stereotype approaches here, $1,000 a month in rent, the normal deposit would be $1,000, if not more. But if there is a $1,000 deposit, if the tenant leaves and they owe $2,000, it's almost certain the landlord's going to apply that debt, the deposit to the debt. So instead of owing $2,000, the tenant would owe $1,000. And whatever interest they'd accrued over the time they were in the place would be applied to the debt as well. So they still owe roughly $1,000, though. The tenant still owes roughly $1,000, assuming that their lease ended at the end of May, that they're leaving, they'd given a notice, they just didn't pay for the last 2 months. The landlord could, of course, chase them for that money, eventually in conciliation court, which, like a lot of courts, isn't really functioning right yet. It will be at some point. Not locked into the governor's moratorium on evictions. These are court decisions on when they're going to open. At some point, they're Supreme Court, Minnesota Supreme Court decisions, and at some point, they're sort of local decisions as well. But at some point, the landlord will have the ability to sue for that $1,000 in conciliation court would be the most likely court the landlord would go to. They could also turn it over to a collection agency, which happens all the time too. Will the landlord just walk away from that $1,000, feel like they're never going to get it back? So what's the point in chasing the tenant? Maybe. I think $1,000 is starting to get to that point where most landlords do something. If a tenant leaves owing a couple $100 and they call me up and say, what's the landlord going to do? It's hard to guarantee that a landlord's going to go to conciliation court or turn it over to a collection agency. There's a possibility that they will, but it's not a certainty in that situation. But it's a harder question if the tenant is leaving in the middle of their lease, right? So if the lease was going to extend through the end of September, for instance, so the tenant had another, let's see, July, August, 4 more months to go to pay, they'd owe another $4,000 on top of what they already owe. Then the landlord could, in theory, sue for the remaining 4 months. So maybe it would be $6,000. They owe $2,000 from April and May plus the rent through the end of September. Again, the landlord should apply the deposit to what's owed. Now, if there were damages, the landlord was going to try to deduct the reasonable cost of the repairs that they might have to make when the tenant vacates. But other than that, the landlord might have a claim against the tenant for unpaid rent through the end of the lease, unless somebody moves in. If somebody else moves in, then the current tenant, the tenant that's leaving, their liability stops effectively when the new tenant moves in. If the landlord had to go lower, the rent had to be $950 because they were having trouble attracting anybody at $1,000, then I think the landlord would have a claim for $50 a month difference. Cover costs is what we call that. But I think the landlord has every incentive to try to re-rent. The law in Minnesota does not require them to re-rent, but almost every landlord from a business perspective will try to re-rent, because chasing that person who left in the middle of a pandemic and their future looked pretty uncertain about being able to pay anything ever seems like a bad bet versus somebody who moves in newly and probably will pay a first month's rent and the deposit, so the landlord at least has that money coming in. So the landlord's going to try to re-rent almost every time, but the market is not what it was 3 months ago even. So it might be harder for landlords to fill the places again. But anyhow, that is the concerns I would have about a tenant leaving, owing a bunch of money, and what I'd be covering with them if they were calling the tenant hotline.
Yeah, excuse me, there's a question. Can you explain sort of the differences between the federal CARES Act eviction suspension and suspension of late fees and the states, and as far as the implications for the specific dates and et cetera?
Yeah, so we have not talked about late fees yet today. Late fees are not allowed under the CARES Act. So again, what we're talking about with the CARES Act is a landlord can't file an eviction for non-payment of rent. That's the only topic they can't file the eviction for. But they're not allowed to charge late fees either. The state moratorium on evictions does not have a prohibition on late fees. It's not mentioned. It's not covered at all. Now, it's possible that there could be legislation at some point saying late fees can't be tacked on or can't be recovered by the landlord at any point during the pandemic. In fact, there were a couple versions of legislation at the state level where late fees were retroactively going to be stopped, mirroring the CARES Act. Pardon me, those did not happen. Those pieces of legislation did not pass. There's I don't think it's a certainty, but a very strong likelihood there will be a special session this year. I think a much higher percentage than normal. Special sessions don't seem that special, honestly, much anymore. They seem to happen fairly regularly, as both sides can't seem to come to agreements, and then the governor requires them to come back, and we've had shutdowns over the years, things like that. But if the governor decides to declare an extension of the peacetime emergency, then our understanding of the state laws are that the governor has to call a special session at that point. The governor has the power to extend the peacetime emergency, but the legislature has the power to end it. It would require a vote ending it in both the House and the Senate. I think it's just a simple majority. I haven't looked at that part of the statute in a bit, but I think it's a simple majority. But both both chambers, both the House, Minnesota House, and the Minnesota Senate, would have to vote to end the peacetime emergency. And that's the concept behind why the governor would have to declare a special session. However, once the governor declares a special session, as I understand it, and I don't work in special session world much, I read the papers and look online like a lot of you do. My understanding is the governor has the power to call a special session, but once the special session is called, the legislature can actually consider any legislation they wish. The governor can sign it or not sign it, but they have the power to decide what to do once the special session is convened, and I think they have the unilateral power to end it as well. Do you know if that's true, Eric, if the legislature decides when to end the special session, or can the governor do that?
I'm not certain of that.
Fair enough. But anyhow, and just to recap, the CARES Act covers only federally subsidized or federally guaranteed housing is the only place that the CARES Act works. So if you have a private owner who has no mortgage, they outright own the building, then the CARES Act has no application if there's no federal subsidy involved in Minnesota. And so that's the key differentiator between when does the CARES Act and when does the CARES Act not apply, and when does it apply, is there a federal presence subsidizing it or subsidizing the mortgage by giving it extra insurance? I mean, they're all federal subsidies of a certain type if you think about it that way. But that's the key question to decide whether the CARES Act comes into play or not.
All right, well, those are...
Looks like we got a couple others here. I see in the chat.
Okay.
And the Q&A.
Yeah, let's take the Q&A one here. If after the tenant abandoned the premises, the landlord takes possession of the premises and make repairs, for instance, isn't it a surrender by implication? So the tenant would not be liable for future rents, even though the tenant abandoned the premises. Looks like Vanessa was the person to ask that question. This is a question that we run into, not in the COVID-19 arena. That's not really a focus of that, but I'm happy to talk about it. To start with, a lot of leases say that if a tenant vacates during the lease, that the tenant still owes their rent throughout the lease. Best guess, in most situations, a judge is going to enforce that the tenant owes the rent through the remainder of the tenancy. I think the more the landlord takes over the space, so if the landlord actually moves back in and they make that their primary residence, they're not collecting rent, right, from a new tenant, so there's no double rent issue. But I think the tenant's argument that the landlord has effectively moved somebody else in that's getting free rent, in this case the landlord or maybe a family member would be more common, that they shouldn't be forced to subsidize that owner or their family member's free rent. That's a better argument. If the landlord says, you know what, I'm going to make some repairs while I'm trying to get this place rented, it's sort of a matter of degrees.
I mean, if the landlord wants to come in and completely gut the place and renovate it so it's unrentable, I think that starts to strengthen a tenant's argument. If they're, making a couple tweaks to change the paint or the carpet, which I mean costs money for sure, but really are designed to make it a more attractive rental. I mean, the landlord's got an argument that they're trying to do everything they can to re-rent the place for the tenant that still owes rent through the end of their lease. So the fact that the tenant gave up the keys and the landlord, I guess, took the keys is not enough to wipe out the tenant's liability through the end of the contract. I think it probably takes quite a bit more than that. Again, we always start at the far end of the spectrum. Somebody else moved in, they're paying full rent that the old tenant was paying, or even more. Sometimes that happens. In that situation, the lease is certainly over for the first tenant. And then you start to get further away from that, far end of the extreme where the replacement tenant has come in and paid the rent. And every step you take away from that, the less good the argument is for tenant number one that they don't owe rent through the end of the contract. Again, I get the argument, and it's something that if you had nothing else as a tenant and you're fighting about this in small claims court, you'd certainly try it. But it's not a guaranteed winner for a tenant to say, I gave up possession, they made some repairs, so I no longer owe the rent through the end of the lease. It's not a sure winner for the tenant.
All right, I'm not seeing any other questions in the chat unless you see anything, or in the Q&A.
Yep, I'm not gonna dive into this topic right now. I'm more or less advertising this, and we'll be mentioning this in our materials that we send out again for next week's session. We are planning to do yet another one of these sessions. We're still getting decent turnouts for these as people want to stay informed during this really uncertain time. And by then we'll have rolled over into the new month, and we'll see sort of how the market is playing out. I doubt we'll have a sense whether the governor is going to extend the peacetime emergency or not. I just don't think that that's going to be declared by then at that point. But on June 1st, Minneapolis is a Minneapolis only rule, a pair of rules that matter quite a bit. Minneapolis has enacted and passed some ordinances that actually take place or are enacted or come into force on June 1st that are specific to landlord-tenant. One of them concerns screening. The other is about security deposit caps that I'm going to talk about next week. Now, we have people watching from throughout the state, so I'm not going to spend the entire time talking about a Minneapolis-specific ordinance. Although, to be fair, St. Paul has proposed ordinances that are similar and in some ways go beyond what Minneapolis has already passed. But anyhow, I'm going to touch on those next week because they will be the law officially then. And so I'll mention those and sort of the mechanics of how they work, and then answer any questions that people have those. But again, they're just about Minneapolis, and so we're not going to spend the entire time talking about them because we're still focusing on kind of that COVID-19 overall theme. But it's an early plug for next week's presentation webinar is we're going to talk about those two new rules that were passed. I believe it was last year they were passed, but actually come into play starting on June 1st. The other two things I'm going to talk about right now, and again, if you have any questions, feel free, but those of you that want to listen, you're welcome to listen for the last 20 minutes. I'm still talking COVID-19 material. So I'm going to talk about two last topics, and if you have questions, feel free to jump in that you might have. The first one is amenities. Actually working on what we're referring to as position papers now on amenities. And you're going to get a little bit of my brainstorming session here as I'm putting the article together today. We have been hearing since the beginning of the COVID-19 pandemic that landlords are taking away amenities that are promised in the lease. So we've had some really, I think, critical things like laundry facilities, where landlords have taken away laundry facilities. And then it goes all the way up to golf simulators, which I don't think anybody would call a critical thing. I played golf before. I like golf fine, but do I need a golf simulator? Is it an essential? Certainly not. However, the question we're getting from tenants about amenities is, hey, wait a second, I'm paying, $1,500 a month in rent for a place, or $1,000 a month for rent in a place. And I was promised the following things. I was promised this 1-bedroom or this 2-bedroom with this number of bathrooms and have a working kitchen, be warm in the winter and cool in the summer. They promised me all this stuff, but they also promised me all these other things. When I look at the ad, they sure do sell these things as things that I'm paying for. And I'm not getting them. They've taken them away. Now, look, I understand why they've taken them away. I don't even really argue with the fact that they've taken these things away as amenities. But should I be paying full rent for a place where I'm not getting everything I was promised? And it's kind of an odd question, again, when we're talking about this pandemic, which has, endangered us all and made all of us incredibly concerned about our health and interaction with other people. But if you're promised a dog walking area and they take away the dog walking area, that might have been one of the deciding factors in your decision to rent a downtown, high-rise rental, right? And I mean, again, I get that is a very first world kind of problem, but it's, if you go to McDonald's and you order a Big Mac and fries and a Coke, and they give you the Big Mac and the Coke and they don't give you the fries, you feel like you should get the money back for the fries that you didn't get. It really is that fundamental of a concept, but I'm trying to fit it into the context of the landlord-tenant law arena in a, COVID-19 pandemic era. Is it viable for a tenant to sue over that? Well, first of all, they can't sue. Can they ask for that kind of money back from a landlord? Well, sure, they can ask. And honestly, we've heard about landlords just doing that, just saying, you know what, this is a hard time for all of us, and we wish we could give you the amenities, but we can't. We've had to lock the door to the gym, to the exercise area. There's no more party room rentals for having gatherings, again, for obvious reasons. But we've decided to lower your rent, $50 or $25 because you don't have access to all those amenities. Now, is that $25 going to break the landlord? I doubt it. I mean, landlords are either going to make it business-wise or they're not going to make it right now. And the $25 they'd knock off of everybody's rent, even in a giant building, while a substantial amount of money, isn't going to make or break them. But it does a couple of things for a landlord, I think. The first thing is it looks good. I mean, landlords almost never talk about tenants as customers, partly because I don't think they like the expression, the customer's always right. There's just more friction between landlords and tenants that probably doesn't make that a tenable kind of business person's creed that works for landlords. But tenants are the customer. And why that matters, and what I'm talking about is that the landlord should want to keep good customers. And one way a landlord can look like they're in it with the tenant, which is a phrase we're all used to hearing from car commercials to, doctors pleading for us to stay at home right now, that we're all in this together thing. A tenant hears from a landlord that they're going to knock a little bit off the rent because they don't have all the amenities they were promised, even if it seems like a token amount, still feels really satisfying to tenants. I mean, honestly, tenants don't call us with that, right? Tenants never call a tenant hotline to say how their landlord is good or treating them well. They call us to say what's going wrong, what they're upset about. But it has come up in other contexts where tenants will talk about other things that they're calling us about and say, well, the landlord did knock off $25 or $50 off the rent. And so it's being mentioned to us, even though that's not why they're calling us. So it is happening where landlords are actually saying, we'll give you a discount on the rent. And I think it's a good sales pitch for the landlord to try to convince the tenant that, hey, we're in this together. And on some tiny level, I think it helps tenants get to that mental point where they're going to say, I'm going to pay my rent, or I'm going to try to pay my rent. It incentivizes them to say, you know what, the landlord's doing everything they can. I need to do everything I can. So when I get that next unemployment check, I'm going to make sure that the landlord gets paid first, or after the groceries, the landlord is next in line. If they're trying to decide which bills to pay, because the landlord seems like they're treating them more fairly. I think it's a good way to build goodwill for not all that much money. In a way, it's free advertising to existing clients, but the difference, or customers, but the difference between a landlord's customers and any other merchant's customers is the landlord's customers, the default, the easiest approach for them is to just renew the contract. Nobody likes to move. I mean, I guess there must be somebody that really loves moving, but almost everybody I've ever met hates moving. And landlords don't really like tenants leaving either, because it costs them money as well. But if a landlord can convince a tenant to stay an extra year because the tenant's thinking, well, this landlord's always treated, you know what, they even knocked off rent during the pandemic. Those are the little kind of seeds that plant in the mind of the tenant that, hey, this landlord's maybe on the above average side, so I'm going to stay with them. I'm not talking about giving up a full month's rent or anything like that, although we've heard of that on the news. There have been stories about that from all over the country. But actually, legally, this is probably the right answer, is that the landlord owes something back for not providing the amenities anyway. So why not just give whether you want to call it a token concession or not, to the tenant about amenities, makes it a happier customer. And if this went to a court, the tenant probably should prevail on the fact that they were paying full price. They didn't get the fries with the Coke and the Big Mac, so they should get money back for not getting the fries. That is the highlight of the McDonald's meal anyway. The fries are the best part. The other topic that I've mentioned a couple of times over the weeks, but I do want to bring up again because this is one that we actually have created a position paper on and made it publicly available, is when the landlord can actually enter the rental unit. We talked about that earlier with repairs, and that's generally not that contentious because the tenant has invited the landlord in to make repairs, so they want the landlord to be present. The place where we're seeing a lot more friction is in showings. So as mentioned earlier, this is the move in, move out season. So tenants are giving notices now for the end of June or the end of July if they have to give 2 months notice. By the way, if you're thinking about giving a notice this week, remember, typically it has to be done in writing. Well, it always has to be done in writing, I should say. Sometimes it can be mailed, sometimes it can be handed in, sometimes an email is enough if that's what the lease says. But it's got to be done in writing, and it has to be properly timed. So in most leases and in most cases, the landlord actually has to be able to receive that notice by the end of this week. So you can't mail it on the 31st of May. That's too late to mail a notice to vacate if it's due by the 31st of May. So if you've been waiting to give the notice, don't wait much longer. Today's already the 27th. Anyhow, tenant gives a notice to vacate for the end of June or the end of July. The landlord wants to show the rental to prospective new tenants. A timeless issue. This has come up since I started working at Homeline in '96. There's a law that predates my tenure. It came to, I think, 94, 95, somewhere in there. The privacy statute in Minnesota on landlord-tenant law says that a landlord is allowed to come in to do showings and for any other reasonable business purpose, as long as they give reasonable notice. But the part that's different now is COVID-19, right? Where having somebody in your home might be without, I don't think this is sounding alarmist. I think this is just sort of a realistic assessment. This might be deadly for the current tenant, for the landlord, for the prospective tenant. They might, contract a disease that could kill them. And it's not that much hyperbole being involved here. So since that's the issue we're dealing with, we look at that statute again, and it's got this interesting phrase in it that says, under the circumstances. Under the circumstances, is it reasonable for a landlord to enter for the ability to do a showing? That's the legal lens we have to look at this question through. So if the current tenant says, yeah, come on in, I'll let you see the place, great. There's not really anything more that needs to be done. But what if the current tenant says, I don't want you in here? I'm sick, or I've got a kid that's immunocompromised, or I'm elderly. All kinds of reasons why somebody wouldn't want the landlord coming in. Even a completely healthy person that's 25 years old might not be willing to let a landlord come in with a prospective tenant. So what are the solutions there? Well, one practical solution is to help the landlord. The current tenant helps the landlord do a virtual tour. So photos, maybe even a video. The current tenant agrees to clean the place up, make it look as showplace worthy as they can. Make the bed, do all the dishes, put away the boxes, make it look as nice as they can, then take a bunch of pictures, send them on to the landlord, then they can use them for virtual showings. Realtors have been doing these for years. Landlords do them to some extent, but they could do them more. And we have seen a lot of tenants that are shopping for places not actually physically in person see that next place. I'm not sure that I'd call that the standard right now, but it's getting close to the standard in the COVID-19 era, where it's only virtual showings that are occurring. Some landlords, though, are insisting on doing in-person showings with the prospective tenant. So they'll tell the current tenant, we're coming in to do a showing. And the current tenant says, I don't want you in here. And that's the place where we really hit, brick wall against brick wall. What if the current tenant won't let the landlord in? Landlord calls the police. Hey, police, get them to let me in. And the police say, wow, we're not sure. This feels like a civil matter to us. And that's almost certainly what they're going to say. And it almost certainly is a civil matter. I don't see that there's a criminal context at all, unless the landlord tries to break in, at which point it's probably trespassing. If the tenant puts their dresser in front of the door, what makes it so the landlord simply can't get in, what can the landlord do? Well, they could go file an eviction, if they were allowed to file an eviction. But we have the governor's moratorium on evictions, which in Minnesota isn't just non-payment cases, it's everything except illegal drugs, illegal guns, prostitution, stolen property, and endangering the safety of others. I don't see how that fits into any of those categories. So the landlord's primary remedy, if the tenant refuses to allow the prospective tenant in, is to file the eviction, but they can't file the eviction until the moratorium is lifted. So a tenant has more bargaining power right now to stop the landlord from coming in the COVID-19 eviction moratorium era that we're in. That's just how it works. And so is there another penalty the tenant might face if the landlord can't get in to do a showing? Yeah, I guess the landlord could argue that, hey, look, you cost me rent because I couldn't re-rent the place, I couldn't show the place, so I had to let it sit empty for a month after you left, and I lost rent. Well, you know what? The landlord could sue eventually for that money. Might they win? They have a shot. We can't know what a court's going to do with that, because the court might say, well, under the circumstances, landlord, you didn't have the right to come in. Sorry, I don't think the tenant had to let you go in. That might be the decision a small claims court referee gives, but we don't know, because the courts are closed, so we haven't really had a chance to see how that would play out at a court setting. Did we get another question on the chat there, Eric? I think we did.
Yeah, I think giving a discount on the rent is definitely a way for landlords to avoid a future rent escrow lawsuit or withholding of rent, especially since some places have an explicit amenity fee built into rent. If the tenant is paying for the service but not getting it, there's a problem. Definitely a good practice for landlords to give a discount. Yeah,
thanks for that. I guess it's just a comment, really, Carlton, but I appreciate the comment. And hello, hope things are going okay. I've known Carlton a long time. Yeah, one thing you mentioned there is something I guess I didn't touch on, an amenity fee. If there's actually an amenity fee built into the lease and those amenities are taken away, what the amenity fee really helps a tenant with footing-wise there is to figure out what it's worth, right? A lot of landlords simply fold in all the things that are included into a rental into the total price, so it's almost unknowable what the exercise room is worth, or what the party room rental availability. My rental's probably the wrong word, that you can sign up for using the party rental room. Or party room, you don't actually have to pay a fee. Sometimes you do, sometimes there's a deposit for the party rooms, but an actual rental, you might not even have to pay that. But anyhow, it can be difficult to figure out how much each amenity is worth. I think a gym is actually one of the more calculable ones, because you can look around at various types of gym memberships. You could look at what it costs to go to the Y or Lifetime Fitness, or one of the ones where you use a key like the Anytime Fitness. And a tenant, I think, could take one of those bills, or the average of all the bills, for the lowest price, cut it in half, and sue for that amount. They probably have a pretty legitimate argument. I think a judge would have a tough time saying they're asking for way too much money in those situations. But if a landlord is actually named an amenity fee, then it's a lot easier to calculate what that is worth. I think the one that would be, we don't actually see landlords doing this, but if there's a garage, a specific garage space promised to a tenant, and they're paying, $50 a month, kind of a common rate in the metro area for a parking spot, and then the landlord has to take away that garage spot because they decided to tear down the garage area and they're going to build a new 8 units in that space where the garage used to be. the landlord clearly doesn't get that $50 a month anymore from the tenant who was paying for that parking spot that no longer exists, right? And for right now, the amenities that tenants are paying for, they legally exist, but they're not allowed to use them, so they might as well not exist. So an amenity fee, if that's built into the lease, I think absolutely answers one of the hardest questions about how could a tenant sue or what would they sue for, and that is, what would be the right number to sue for? The amenity fee really would make it a lot more secure footing for the tenant going forward. But Carlson's other point about how this is a good practice for landlords to give a discount, again, I hadn't really phrased it this way until I've just been thinking it through, talking out loud basically right now, that this is the best, maybe not the best, but it's one way for a landlord to advertise. And if landlords advertise anyway, if they pay any kind of advertising fee, they could justify this as a form of advertising by giving a discount to existing tenants. And, honestly, it's the kind of thing that if you look up, if you do a Google search on landlords, most of the news is not good, right? I mean, we don't hear a lot of good news about landlords. I think there was a landlord a couple of years ago who actually donated a kidney to a tenant, and that was, if you Google up landlord tenant good news stories, you'll see that. And we've seen during the pandemic that, you read about a landlord in New York who waives the rent for his entire building for April or whatever. So there are good news stories, and I'm not just talking about free things that landlords give away, and most landlords do a lot of good things for their customers. That's why they keep them. But this is the kind of thing that might get mentioned on a social media level. And I'm not going to say that it's going to go to 10 billion people, but if I'm a tenant and I'm 22 in that rental rate range, or I'm 68 where I'm looking for, rentals for the next 10 years before I move into assisted living or something like that, I probably have friends that I know on social media, and they're going to see that I had a landlord that was reasonable to the point of being, worth talking about on social media or to friends. And so anyhow, I think it's a great way for a landlord to advertise right now. And so I really appreciate that amenity fee notion, Carlton, that you mentioned that, because like I said, I'm working on this position paper, and I'll make sure to include that, because the speculation about damages is so hard to figure out what it would be for the removal of the amenity that a tenant had been promised originally.
All right, well, we are leading up to 2:30 here, so I think we can call that a wrap. And again, in the chat, I'm just putting the link to our resource page. Recordings of previous seminars, webinars are on that page, and you'll get a follow-up email with a link to how to register for next week if you're interested.
Thank you very much, all. See you next week.
Thank you.